Sexual harassment of women at workplaces and remedies. Today in the series Knowledge is Power, I am going to discuss about the issues relating to harassment of women at workplaces and the laws which govern their protection and related matters briefly. Protection against sexual harassment and the right to work with dignity at work are universally recognized human rights by international conventions and instruments and Convention on Elimination of All Forms of Discrimination Against Women. The convention has been ratified by our country on the 25th June 1993. In 1997, Supreme Court of India laid down guidelines and norms to be observed by the employers at workplaces as well as other responsible persons or institutions for the prevention of sexual harassment of women in workplaces, which would be binding and enforceable in law in the case of Visakha and others versus State of Rajasthan. They should be strictly observed in all workplaces for the enforcement of the right to equality of the working women. The Honorable Apex Court held that it shall be duty of the employer or other responsible personnel in workplaces or other institutions to prevent harassment and to provide the procedures for the resolution, settlement or prosecution of acts of sexual harassment by taking all steps required. Sexual harassment has been defined to include such unwelcome sexually determined behavior, whether directly or by implication, as physical contact and advances, a demand or request for sexual favors, sexually colored remarks, showing pornography, and any other unwelcome physical, verbal, or non-verbal conduct of sexual nature. The Apex Court directed that all employers or persons in charge of workplace, whether in the public or private sector, should take appropriate steps to prevent sexual harassment and they should take steps to prohibit sexual harassment at the workplace. Government and public sector bodies should incorporate rules relating to conduct and discipline prohibiting sexual harassment and provide for appropriate penalties in such rules against the offender. Private employers should take steps to include the said prohibitions in the standing orders under the Industrial Employment Standing Orders Act 1946. Appropriate working conditions should be provided in respect of work, leisure, health and hygiene to further ensure that there is no hostile environment towards women at workplaces and no employee woman should have reasonable grounds to believe that she is disadvantaged in connection with her employment. Sexual harassment of women at workplace prevention, prohibition and redressal Act 2013 is enacted by the Parliament considering the judgment of the Honorable Apex Court and the Convention on the Elimination of All Forms of Discrimination Against Women, and in view of the continuous fight of equal rights by the women organizations. More than 65 years after our country got independence, women's rights are finally recognized. It provides that no woman shall be subjected to sexual harassment at any workplace and provides protection against sexual harassment of women at workplaces and for the prevention and redressal of complaints of sexual harassment. Sexual harassment results in violation of the fundamental rights of women to equality under Articles 14 and 15 of the Constitution of India and her right to life and to live with dignity under Article 21. Right to practice any profession or to carry on any occupation, trade or business includes a right to safe environment free of sexual harassment. Implied or explicit promise of preferential treatment in employment, implied or explicit threat of detrimental treatment in employment, or explicit threat about present or future employment status and other such circumstances amount to sexual harassment. Interference with work or creating an intimidating or offensive or hostile work environment for any woman or humiliating treatment likely to affect her health or safety are also considered sexual harassment. Internal complaints committees. Every employer of a workplace has the mandatory duty to constitute an internal complaints committee at all administrative units or offices to inquire into the complaints of sexual harassment. The internal committees shall consist of a presiding officer who shall be women, employed at a senior level at a workplace from amongst the employees, and not less than 2 members from amongst employees, preferably committed to the cause of women or who have had experience in social work or have legal knowledge, and 1 member from among non-governmental organizations or associations committed to the cause of women, or a person familiar with the issues relating to sexual harassment. At least 1/2 of the total members so nominated shall be women. The presiding officer and every member of the internal committee shall hold office for 3 years or less from the date of their nomination as specified by the employer. Every employer shall provide a safe working environment at the workplace, which shall include safety from the persons coming into contact at the workplace. The employer shall display at conspicuous place in the workplace the penal consequences of sexual harassments and the order constituting the internal committee, and organize workshops and awareness programs at regular intervals for sensitizing the employees with the provisions of the Act. The employer also shall provide necessary facilities to the internal committee or the local committee for dealing with the complaint and conducting an inquiry, and assist in securing the attendance of the respondent and witnesses before the internal committee or the local committee. The employer shall provide assistance to the woman if she chooses to file a complaint in relation to the offence under the Indian Penal Code or any other law in force, and cause to initiate action against the perpetrator, whether employee or not, and treat sexual harassment as a misconduct under the service rules and initiate action for such misconduct. If the presiding officer or any member of the internal committee has been convicted for an offence or an inquiry into an offence under any law for the time being in force is pending against him, or he has been found guilty in any disciplinary proceedings, or a disciplinary proceeding is pending against him or her, they shall be removed from the committee. Local committees. Every district officer shall constitute a committee to be known as the local committee to receive complaints of sexual harassment from establishments, whether the internal committee has not been constituted if the complaint is against the employer himself. The local committee shall consist of a chairperson to be nominated from amongst the eminent women in the field of social work and committed to the cause of women, and 1 member to be nominated from among the women working in block, taluk or tehsil or ward or municipality in the district, and 2 members of whom at least 1 shall be a woman. to be nominated from among us such non-governmental organizations or associations to commit the cause of women or a person having experience about the issues relating to sexual harassment, among whom one of the nominees should have a background in law or legal knowledge. Complaint of sexual harassment. Any aggrieved woman can make complaint of sexual harassment at workplace to the internal committee or the local committee within a period of 3 months from the date of incident, and in case of a series of incidents within a period of 3 months from the date of last incident. If such complaint cannot be made in writing, the presiding officer or any member of the internal committee or the chairperson or any member of the local committee shall render assistance to the woman for making the complaint in writing. The time limit can be extended if there are circumstances which prevented the woman from filing a complaint. Where the aggrieved woman is unable to make a complaint on account of her physical or mental incapacity or death or otherwise, her legal heir or such other person may make a complaint. During the pendency of any inquiry, if the victim requests the committees to transfer her or the respondent to any other workplace, the employer has to obey the recommendations, and if required, the employer has to grant leave to the aggrieved woman up to period of 3 months, and the leave granted to the aggrieved woman under this section shall be in addition to the leave she would be otherwise entitled. Inquiry into complaint. In receipt of the complaint, the internal committee or the local committee shall proceed to make inquiry into the complaint in accordance with the provisions of the service rules applicable to the respondent, and in case of a domestic worker, if prima facie case exists, forward the complaint to the police within a period of 7 days for registering the case under the provisions of the Indian Penal Code and other relevant provisions. Inquiry report. Within 10 days after completion of an inquiry, the internal committee or the local committee shall provide a report of its findings to the employer. If the harassment is proved, the committee recommends to the employer to take action for sexual harassment as a misconduct and to deduct from the salary or wages of the respondent such sum to be paid to the aggrieved woman or to her legal heirs as it determines. If the employer is unable to make such deduction from the salary of the respondent due to his being absent from duty or cessation of employment, it may direct the respondent to pay such sum to the aggrieved woman. If the respondent fails to pay the sum, the amount shall be recoverable as an arrear of the land revenue. The employer or the district officer shall act upon recommendation within 60 days of its receipt by him. The mental trauma, pain, suffering, and emotional distress caused to the aggrieved woman, the loss in the career opportunity due to the incident of sexual harassment, medical expenses incurred by the victim for physical or psychiatric treatment, the income and financial status of the respondent, feasibility of such payment in lump sum or installments shall be considered by the committee in determining the compensation. The contents of the complaint and the identity and addresses of the aggrieved woman, respondent and witnesses, and information relating to conciliation and inquiry proceedings, recommendations of the internal committee or the local committee, and the action taken by the employer or the district officer under the provisions of this Act shall not be published, communicated or made known to the public, press, and media in any manner. If any person entrusted with the duty to handle or deal with the complaint, inquiry, or any recommendations or action to be taken publishes the same, he shall be liable for penalty in accordance with the provisions of the service rules. Before initiating an inquiry, the committee may take steps to settle the matter between the aggrieved woman and the respondent through conciliation on the request of the aggrieved woman, but no monetary settlement shall be made as a basis of conciliation. If any term or condition of the settlement arrived during conciliation has not been complied with by the respondent, the internal committee or the local committee shall proceed to make an inquiry into the complaint or forward the complaint to the police. The court has powers to order payment of such compensation to the aggrieved woman by the accused, considering the pain and suffering of the aggrieved woman. The internal committee or the local committee have the powers of civil court to summon and enforce the attendance of any person and examining him on oath and requiring the discovery and production of documents and inter alia others. The inquiry shall be conducted within a period of 90 days. If the employer fails to constitute an internal committee or takes action on the inquiry report of the internal committee or the local committee to take action for sexual harassment as a misconduct against the culprit, or fails to deduct the amount from the salary or wages of the guilty to be paid to the aggrieved woman or to her legal heirs as per the findings in the inquiry report within 60 days from the receipt of the report, or contravenes or attempts to contravene or abets contravention of the provisions of the act or rules, he shall be punishable with fine which may extend to 50,000 rupees. The employer shall submit annual report mentioning number of cases filed and their disposal to the district officer, and if he fails to do so, he shall be punishable with fine which may extend to 50,000 rupees. If any employer commits and is convicted of the same offence, he shall be liable to twice the punishment, and his license shall be cancelled or withdrawn by the government, and he cannot continue in business anymore. Any aggrieved person or any person authorized by the internal committee or local committee can file a complaint in a court of metropolitan magistrate or a judicial magistrate of the first class. Women employees also have rights to protect their fundamental rights to life and liberty by approaching the constitutional courts for implementation of the Honorable Apex Court's judgment in Visakha case, and they can also report to the police regarding any sexual harassment incidents directly without waiting to give report to the complaints committee or the local committee. It is sad that even though the law mandates that the employers shall constitute internal committees and submit annual reports and hold meetings of the committees, more than 80% of employers are not following the dictates, and the women are not initiating action to punish the culprits, maybe due to innocence and ignorance of law. Hope every woman employee or the worker learns the purport of the laws and protect themselves from those who infringe their fundamental rights to work with dignity and life and liberty.